Welcome to Insta Legal. In today's times, when everyone has been badly affected by COVID, the coronavirus, there have been a lot of unfortunate deaths, and people have not been able to understand what to do, how to get their certificates, and how to get the property transferred. If it is a immovable property, how to get the letters of administration, etc. So I have based my question for today's video is on the recent questions which have been asked, that is, how do I get a succession certificate? Now, first, we need to understand what basically is a succession certificate, whether it is actually there is any difference between a succession certificate and a legal heir certificate. So let's first understand the term succession certificate. A succession certificate is a certificate which is required to be taken in case the deceased died intestate and without appointing a nominee. Now, this word nominee comes when there are bank accounts, when there are mutual funds, when there are debts, etc. Now, what does it establish? It establishes the authenticity of the legal heir of the deceased, giving them the authority to inherit the assets, including the debts of the deceased. It is obtained for movable property, and for immovable property, letters of administration is required. Now, a succession certificate, please understand, does not establish a title of the guarantee as the heir of the deceased. That would be done only by the legal heir certificate. So succession certificate in that way is different from a legal heir certificate. They are not synonymous. And a succession certificate will only furnish the grantee the authority to collect his debts and allow the debtors to make payments to him without incurring any risk. So now that we have understood what is succession certificate, what is the procedure to obtain, let's find out. You initially have to file a petition before the district judge. Basically, no district judge is giving the kind of a certificate. It is always a delegated judge, which could be a civil judge of a junior division or a judicial magistrate who have been delegated by the district judge to act as a district judge to grant the certificate. So you have to file the petition either within whose jurisdiction the deceased was residing at the time of his death, but when there is no fixed residence, it can be applied where the deceased property was situated. For example, if a bank of the deceased is situated in Delhi, but the deceased died in Mumbai, then either of the place, either in Bombay or either in Delhi, the application for obtaining the succession certificate can be filed. Once the application is to be filed, the petition is required to mention as to the person who is the petitioner, what was his relationship with the person who has been deceased. All the name of the legal heirs is to be mentioned. The particulars of the deceased deaths have to be mentioned with regard to the time, place, and the reason of his death. The person claiming the succession right has to give his own particulars as to what would be his right under the succession certificate, and it has also to be declared the rights, the assets, the debts and the securities which are there of a deceased person. Please note the death certificate is a must to be annexed with the petition. Whereafter, the notice will be issued to all the parties, which would include the legal heirs, all the legal heirs, and publication is also made in the newspaper specifying a time within which objections may be raised. Now, if no objection is received, on the satisfaction of the court after hearing the petitioner, the order granting succession certificate is passed. But if there have been objections which have been received, after hearing the parties raising the objections, the decision is passed either for granting the certificate or refusing to grant the certificate. Now this, once the court refuses to grant the certificate, it is appealable order, and even if it is granted, if somebody else challenges the right of obtaining the succession certificate, he may do so within the limitation period before the Honorable High Court. Now when the certificate is issued, it specifically must specify the debts and securities, and it should specify empowering the person getting the certificate to receive interest or dividends or negotiate or transfer the securities or both. So hence we have seen the procedure is quite simple. It usually takes around 6 months for getting a succession certificate. Thank you very much.